We're going to get started with our directors panel now. You can see there are 5 chairs and 4 humans in the person. However, to this side, Kate Zoladz, and we'll be introducing Kate in just a moment, but hopefully this technology will work out. We'll see. Let me first introduce Jina Choi. Jina has been a key part of this conference since we started it in 2014. For years, she was here in her capacity as the director of the SEC's San Francisco regional office, where she was on the staff for over 16 years. And after that, she was a partner at Morrison and Foerster in San Francisco for many years until December of 2023, when she joined the U.S. Attorney's Office in the Northern District of California as chief of the Corporate and Securities Fraud section. Welcome, Jina, and congrats on your new position.
Thanks, Bruce.
Our moderator is Jordan Eth. Jordan's a partner at Morrison and Foerster in San Francisco. He is co-chair of that firm's Global Security Litigation Enforcement and White Collar Defense Group, and one of the leading securities litigators in the United States. Welcome, Jordan.
Thank you.
I'm very pleased to introduce Michele Wein Layne. Michele is counsel at O'Melveny & Meyers, and like Jina, has been with us every year since 2014. She was, of course, until last year, the regional director for the SEC's Los Angeles office, a position she held for over 11 years as part of her over 27 years of service at the SEC. Michele, welcome back, and thank you for joining us.
Thank you.
Monique Winkler is the regional director of the SEC's San Francisco office. After joining the San Francisco office in 2008 as a staff attorney, she went on to become an assistant regional director in 2015, associate regional director in 2019, and regional director in 2022. Welcome, Monique, and thank you so much for joining us.
Thank you.
And finally, in Los Angeles, thank you so much for joining us remotely, Kate. This is Katharine Zoladz. She is the regional director of the SEC's LA office and has been since November of 2023. She previously served as the LA office's acting co-director and as the associate regional director for enforcement. Kate, so great to have you with us, and I look forward to hearing from you.
Great, thank you. Hope you can hear me loud and clear.
We can hear you great. Thank you.
Great.
Jordan?
Thank you, Bruce. Well, Michele, do you feel a little outnumbered here?
Yes, I do.
I mean, we have like government, wherever you look, right?
All right, I'll do my best.
Do your best. All right, so
She
first
feel
top,
like she's amongst friends.
amongst
Always.
friends.
Always.
And you're all going to be cooperative and collaborative.
Yes.
Right? And we've
Yes,
heard a lot about
absolutely.
that today. All right, so let's talk about AI, because everyone's talking about AI, right? So a couple of quotes about AI. It's been called the most transformative technology of our time. It holds the promise of enhancing every aspect of our lives. Those are quotes from SEC enforcement personnel, right? If that's not hype, I don't know what is, but Kate, we'll start with you. How do you determine what AI hype is, or I guess the term is now what? AI washing? Is that what people call it? So how do you make that determination when it's like the biggest thing since the printing press?
So before I get into that, because I know I will forget, I'm just going to give the admonition, and I'm going to give it for Monique so she doesn't forget as well. So our comments today are provided in our official capacity, but do not necessarily reflect the views of the commission, the commissioners, or members of the staff. And I hope I didn't kind of step in the great introduction that you gave there, Jordan.
No.
So really the question of, is AI the latest thing? Is AI washing the new crypto washing? AI washing, is it the new thing? So, I think it's yes and no is the answer to that question. In many ways, I think we see the same general disclosure issues we always see with AI. It is just the latest spin in one way of looking at it. There's no doubt that there's immense market interest in AI. And elevator investor interest gives companies financial incentives to exaggerate or make misleading statements about their supposed AI activities or products. And the recent AI washing cases that we just brought are a good example of this. So in March of 2024, the SEC announced settled charges against 2 registered investment advisors. One firm claimed that it used AI to analyze client data and predict which companies were going to make it big. And the other claimed it provided expert AI-driven forecasts. But both statements were false and misleading. Neither had the AI capabilities that they claimed. And I think, the takeaway, do what you say and say what you do, is the same as it ever was in those cases. And I think that same principle holds true for public companies who may have reasons to disclose AI-related information.
So what about on the Oh, I'm sorry, Kate. Just going to ask Michele, in light of that, or did any kind of special counseling on AI for companies and for your clients?
Yeah, I mean, obviously that's an important issue that a lot of companies, law firms too, the consulting firms are all testing the waters with AI. I know at our firm, since 2023, we've been investigating using certain tools, and obviously there's a lot of tremendous privacy issues for attorneys and law firms, and make sure you're using an AI closed system. And in fact, different state bars, including California's, issued a lot of guidance for attorneys and how they utilize AI. But it is a concern, but I have the same view of the AY washing case is that Kate just mentioned. It really harked back and reminded me when the first ESG cases were brought and when the examination report was published in the wake of the ESG initiatives. And essentially, at least, I don't know if the SEC is agnostic on AI, but the statements at the time about ESG is that the commission was agnostic about ESG. But if you are going to represent to investors and clients that your portfolios have certain compositions and you don't have policies and procedures that indicate, in fact, you are doing what you're telling investors and clients you're doing, that's a problem.
So speaking of doing and saying the same thing, so forth, Monique, what about in your office? I'm going to ask Jina the same thing. Are you using AI, training people in AI, and then personally, have you used AI, in particular ChatGPT?
I think the answers to all of those questions are no.
No. Okay. No, no, and no.
Although I would say that if the staff is going to be investigating a case that involves AI, it's certainly helpful there for them to have some understanding of how AI is supposed to work, or perhaps does work.
So is there any training going on where people are learning about it? Because I'd like to learn about it.
I think there's some training about investigations into AI, but I don't know. I'm not aware of, I've not received any particular AI. I don't know how to use ChatGPT. Maybe I'm old school.
Jina, how about in your office?
In our office, I do not believe that we are using AI to generate any filings, anything that we would ever submit to the court. But I tried to use OpenAI ChatGPT last night. I actually asked if Gina Choi were to answer Jordan F. on could you come up with some talking points for how the SEC and DOJ should approach AI regulation? And look,
you're not actually going to read that, are you?
No, I'm not. But it came up with
several.
It came up with several talking points that sound really good: enhancing surveillance and detection, ensuring fairness and transparency, collaborating with industry stakeholders, balancing innovation and risk management. But then I asked it to find me some cases on AI, federal cases, and then it said and then I asked it about a case that looked it came up with 5 different cases, and I asked it about a case, Robinson v. State of Connecticut, that sounded a little odd. And then it apologized to me, Jordan. It said, "My apologies for the confusion, but it seems it was a misunderstanding. As of my last update, there is no known federal court case titled Robinson v. State of Connecticut specifically related to predictive policing. It's possible that I generated a fictional case name based on your query."
So it's probably not a good idea to use ChatGPT for a well submission, is what you're suggesting? So I actually, a few days ago, put in Bruce's name, and I said, give me a limerick about the SEC Enforcement Forum and Bruce Carton. And I was going to read it to everyone, but it was so rude and coarse. So I don't know if I'm encouraged or discourage you from trying the same thing, but I couldn't believe it. But you can ask it to give you anything in limerick form, including legal citations or whatever you want. All right.
Wouldn't that be great? A haiku, Monique?
A haiku, you could do that. A haiku well submission. It would be
Maybe
different.
that's a challenge for next year.
Next year.
We'll come up
Next
with
year
a Jordan haiku.
okay? Because every single panel, it's a requirement. I don't know if Bruce mentioned it, but every single panel is going to do this. And Monique, I'm going to ask you. We've heard it's not novel. If it's not novel, why is it on every single panel? If it's not novel, and if it's not novel, can you tell me one other time in the history of the SEC, which goes back to, I don't know, it's like 80 years, 90 years old, when someone got in trouble for trading in the securities of a different company?
So I'm not going to answer your question directly, but I am going to tell you what I think when I hear so many people concerned about it being novel. I wonder what the employees of all your clients are doing, and I have a lot of concern.
They're worried that they're like using things they learn and they're profiting by that?
That would be correct.
And that's a bad thing?
When there's a duty that's breached, it could be a bad thing. Yes.
Okay. So what is the duty? The duty here, so there was a lot of talk about employee, about policies, insider trading policies. Without that policy here, I realize there are other grounds, but without that policy, does that case get brought?
I could see circumstances where that case would get brought, yes.
Okay.
I mean, I think talking, when Gabir was talking earlier, I was thinking, you can't draft away a duty. Like, you can't draft an agreement such that a duty is no longer there when the duty can be found in just a general agency duty to your employer.
And the jury came out with its verdict in what, like 2 hours? Right?
Just a little over 2 hours.
Okay. So, Jina, if this was not all that novel and it was pretty clear cut and in 2 hours they did it, why wasn't it criminal?
Well, I was in private practice when this.
And so you were able to talk them out of it. You talked them out of it. No.
And I think I think I wrote a client piece where I thought that this was exactly the way a case like this should be rolled out. That the civil regulator should bring it. The SEC should bring it. I thought the complaint in Panelette was exquisite. Like, I think the facts, and I actually think the judge and the jury found that as well. That complaint is just a very interesting and unique set of facts, down to the the insider trading policy by the company. The fact that 7 hours after learning about the
7 minutes.
7 minutes after, exactly, 7 minutes after learning about the MNPI in the email, trading occurred. It was a acquisition case, which I think is easier to bring. But I do think that, it's at heart, it's a misappropriation case. The Judge Orrick cites O'Hagan. O'Hagan was a U.S. v. O'Hagan. That was a
criminal case.
That was a criminal case.
Okay. So,
and, just one observation I have is, I know there's been so much hue and cry about the duty and trading and changing insider trading policies, but I do think at its heart it is a misappropriation case, and in every misappropriation case, it's obviously not a classical insider trading case, and the fundamental notion is you have traded on MNPI in breach of a fiduciary duty that you owe to the source of the information. So he had a duty as an employee, and almost every company requires employees to there's a code of conduct or an employment agreement that has confidentiality provisions. So to me, the unique aspect was applying it to a different company than the company they had the MNPI about. But what made, I think, the complaint so compelling, and good facts make good law, depending upon what side of the V you're on, is the facts were really unique and compelling. So I really do wonder how many insight motivation scenarios there really are out there, as opposed to like trading in a competitor at large in a field in which there are a lot of arguable, similarly situated companies. So that's why I think a little bit maybe overreaction.
From the defense side? And is there a way
Even though I'm on that side now.
Is there a way for companies to disown that duty?
I don't think so. I mean,
so a company can't say, don't trade in our securities. Whatever you do with those securities, that's fine. Can't do that.
But also why, I mean, I can't think of like the business case why a company would want to do that. And first of all, like, it's good governance not to have your employees misuse confidential company information for any personal purpose. And secondly, if that's going to create potential insider trading investigations of its employees, that comes at a huge cost and resource disruption and potential reputational issue for the company. So,
Kate, don't want to forget about you. Any comments until the next panel brings up Panuat?
No, I think we've tread that
We've
ground.
covered it. We've covered it. Okay.
Well, one thing I would say though, Jordan, is, that trial team did an outstanding job. Like, hats off to them. Really, I think that trial had a lot of scrutiny. I know, being in the SFRO in any regional office, when the office goes to trial, that takes a lot of resources. And the trial team of Brent Smythe and Matt Meyerhofer, Jason Bussey, and the remarkable Susie Lamarca, legendary Susie Lamarca, who I understand is retiring. I mean, just didn't.
They did, and I'll note, I was actually there in court for most of the trial, and I sort of reminded of that when Kabir was talking about the fact that 99.9% of the people at the SEC are there to be public servants. And they really demonstrated that commitment to public service in that trial, the respect that they showed the judge, the respect that they showed opposing counsel, the respect that they showed the jury. It really made me proud to be part of that office.
So what we have is one case from the Northern District with a jury verdict. And is it up on appeal yet, or what's the status?
We're in the remedies phase.
Okay. So we may, a year or two from now, actually have some appellate ruling on this.
We may
Maybe.
have 6 more panels talking about Panuat.
There we go. Excellent. All right. So let's switch gears just a little bit. Talk about criminal area. Now, we heard earlier about 4 priorities of the Northern District. One priority was fentanyl. One was violent crime. One was IP. And one was, what was that fourth one? Civil rights, right? So, Jina, we also heard something about securities fraud and capital markets. So where do you fit in? And is this a new role that you have? And what is it that you're doing?
It is a new role I have. I think that I'm really glad that Izzy was able to be here this morning with Melinda and kind of set forth the priorities of the office as he sees them. And I think they are really compelling and important priorities. I think they gave you a sense of how broad, the Northern District is, how special it is, and, public safety is very much at the forefront of folks' mind and Izzy's mind as well. He talked about the fentanyl crisis and the Tenderloin focus, and there is an all hands on deck. So it will be good for you to know that I have my first fast track case.
Oh, so all hands on deck. It's not just like a particular unit. It's everybody in the office.
No, my understanding is our first assistant has a fast track case. Our criminal chief has a fast track case. And
fast track, just for everybody, what is a fast track case?
So those are cases that originally started at the state. They involve possession with the intent to distribute either fentanyl or methamphetamine. And we take those into the federal court system.
But you're also doing something on securities fraud.
That's right.
Right. So
that's right. And so I would say,
I think we could all agree, fentanyl bad. Fentanyl bad.
that's good.
Get
That's
rid of
good
it.
that we all
Securities
know
fraud, it depends. So
I will say that I think that when Izzy was speaking, I think another one of his priorities is Silicon Valley.
Okay.
And I think that looking for fraud and protecting innovation in Silicon Valley is really important.
Okay. But your role is a new one. It's a new position, right?
It's the chief of the corporate and securities fraud section, and the corporate and securities fraud section has existed before me.
Okay. So, and we heard a little bit earlier about what could make an insider trading case criminal. And it's always been a little bit of a mystery to the defense bar. Where is the line between civil pretty bad, civil really bad, oh, now it's criminal, and how you make that determination, and then also how you work with the SEC to coordinate which ones will become criminal and which ones don't?
I think a lot of it has to do with CENTER, state of mind. I think a lot of it has to do with our burden, as Ben referred to earlier this morning. I think we have to be careful about our resources and make sure that we're using them carefully, strategically, to make sure that we are creating deterrent for the community. And also to give the community a sense that we are the cop on the beat and that we're here. I think there is a large emphasis on making sure that conduct that occurs in our district kind of stays in our district, that we're investigating it, that we're litigating it.
Wait. Conduct that is in our district stays in our district, meaning, what does that mean?
I think that our district, and I felt this at the SEC, the San Francisco region, has so much innovation, so many public companies, so many pre-IPO companies that a lot of other regions and a lot of other offices tend to look towards our region to bring cases and investigate. So
are you saying that this is for, you want the Northern District to retain the cases involving companies out here?
Yes.
Okay. So Kate, there's a new task force or some sort of cooperation in between your office and the U.S. Attorney's Office in the Central District?
So there's a new task force or strike force, and I think the cooperation with that strike force is kind of the corporate cooperation that we've always had with the Central District. So in October of last year, the Central District announced the formation of the Corporate and Securities Fraud Strike Force, and that's a new section that focuses on complex corporate crimes, abuses by company insiders, and offenses that impact the financial system. So it was designed to expand and prioritize complex corporate and securities fraud investigations. It's led by Brett Sagel. And earlier this month, the SEC's LA office brought parallel charges alongside the strike force against Fat Brands, its founder, former CEO, and current chairman, Andy Wiederhorn, and its former CFOs concerning Fat's disclosure about related persons' transactions with Wiederhorn and his family.
And Monique, what about collaboration with the criminal authorities in the Northern District? What is it that your office has been doing?
We have for a long, long time, and we continue to work in parallel with the Northern District. I regularly talk to Jina. I regularly talk to Izzy. I think our offices work well in parallel.
Okay. Wanted to switch gears a little bit, now talk about whistleblowers. So every year I see the reports, and every year there are more. And every year there are more, and there's more money given out. Why is that happen? Is it that there's more fraud? Is it just that the plaintiffs' whistleblower bar is getting better? Or what is the reason for that? And maybe Monique, I start with you on that.
I'd venture a guess that it's both.
So you think that it's just the sophistication of the plaintiff's bar? And so...
I mean, we do see a lot of former SEC staffers now representing whistleblowers.
So Michele, in light of the fact that whistleblowers are now becoming more and more common, what does that do from a defense side in terms of how you counsel clients?
Well, on a variety of levels. So kind of the simplest level is counseling clients on their employment severance settlement agreements to not run afoul of 21 F-17, which Gerber mentioned in his discussion with Dabney. It gave rise to a sweep almost 8 or 9 years ago. And then there's another sweep going on, just charging companies who have language in their agreements that can be seen to impede whistleblowers. And there was a whole spate of actions last fall charging companies for that. And so that is one aspect. But the other aspect is the frequency with which whistleblower complaints are made internally. And then, at what point does a company, for instance, refer that to outside counsel, a special committee to look into, to review. And then, of course, companies have their own internal staff that reviews them and responds to them as well. And this may just be anecdotal because I've only been doing this since August, but I've had 2 matters where the whistleblowers raise allegations that are really unfounded, and then
What a shock. Yes.
and we would see that when I was at the SEC too, but it's sifting the wheat from the chaff, and there were also not infrequently a whistleblower might complain about X, and then once the SEC is inside in your kitchen, they could find other things, which happened on several occasions, sometimes much bigger, more egregious violations than what they purported to believe were the violations. But putting that aside, it can be a pretty daunting and expensive exercise for a company to have to, investigate and respond to some of those.
So do you feel you have to chase down every whistleblower allegation?
I mean, certainly as a defense counsel, we're not asked to do that, but I do think it's just a good practice when a complaint comes in, unless on its face it just seems utterly unfounded, a company has to take it seriously and review it.
Mm-hmm. Now, you mentioned severance agreements and companies not always having the right language. Monique, are you seeing problems in that area?
We are, and I think there was some talk amongst this group early on that we might call those footfalls.
Footfalls, yes. You lose a point. If it's a footfall, you lose the point.
I would definitely not call them footfalls. I mean, when you think about sort of the disparity between who's drafting those agreements, who's reviewing those agreements, and then who's subject to those agreements, it's definitely not a footfault if you're the employee reading that agreement, something's wrong and you think you can't do anything. And that is far from a footfault. And Michele mentioned, I mean, there was the sweep 8 years ago. There's been a recent series of charges. I think in 2023, there were at least 4 cases brought, and one against D.E. Shaw, CBRE, Activision Blizzard, Monolith Resources.
So the severance, I can understand if there are severance agreements that say, by the way, you can't talk to the government no matter what. That's one thing. But what if it's just sort of a general, broad severance agreement and says you have an NDA, you can't disclose anything that you learned here, and it doesn't on its face single out the government as a prohibited party?
I think that could be problematic. I think it's facts and circumstances, but I think if it's that sounds to me pretty much like a broad prohibition, which could be problematic.
All right. And Kate, do you have any comments on that issue?
Yeah, no, I would agree with that.
Okay. All right. So along those lines, in terms of whistleblowers and encouraging them, we've heard about all these new programs. There's a Northern District of California U.S. Attorney's Office whistleblower pilot program that was started just a few months ago. There's now the Criminal Division's voluntary self-disclosure pilot program. There's also a Southern District of New York disclosure program. They've got 3 different programs, Jina, right?
Yes.
Okay. Now I'm a lawyer representing a client and saying, you know what? Maybe we should self-disclose. Where do I go? Which one do I read them and say which one's the best one for me, or who do I know, or how do I handle that?
I think you should send them to me to help them figure out which option.
It's a deal.
Yeah.
It's a deal. Okay.
Exactly.
Send them to Jina.
Right. I think, yeah.
So why are there 3 different, Southern District? Is there a competition going on here, or why are there different ones, and rather than just here is the program for DOJ?
I don't think of it as a competition. We're all part of the Department of Justice, and I think we all want to see misconduct that is undetected be discovered. I think that Izzy this morning talked about feeling like that we're bold and that we wanted to get our pilot program out there. I think our section thought carefully about whether it would be worth having a whistleblower pilot program and have those incentives, those types of carrots out there. And that's something that we put in place.
So Michele, in terms of all these different programs, how do you counsel clients to go to which one and how best to handle it?
Well, certainly, it seems like the one that the Northern District of California has rolled out for individuals is pretty specific, right? Like, you have the incentive of an NPA if you come in first and disclose your own misconduct and presumably have information about misconduct of others. I think, we're still waiting to see the DOJ policy for the companies, and that, I don't know that it's really going to be a game changer in the sense that I know in the speeches around the ABA White Collar Conference, it was announced really to be an adjunct to the SEC's whistleblower policy to cover private companies, which of course the SEC still has jurisdiction over as far as making, misrepresentations to investors. So it's not entirely clear exactly like where that space is that isn't complementary to the SEC when you're talking about corporate fraud. But nonetheless, I don't know that it's binary to report to one or the other. And already, like the case has been, and Monique and, Jina and Kate can speak to this, oftentimes when whistleblowers come forward to the SEC, they also would go to the FBI and or DOJ already, and or, dealing with the anonymity issue, the SEC can, apprise, refer the whistleblower complaint to DOJ.
So Monique,
So I don't
go
know
ahead.
like what the problem is that DOJ is trying to solve by creating its own whistleblower program that is aimed at corporate wrongdoing.
Monique, have you seen any changes with these new programs in terms of people coming forward?
No, although the number of whistleblower complaints that the SEC gets is so high, it would be hard to actually detect a change. I mean, I could see, I can't imagine that it would be anything but positive for our program. I mean, since we work in parallel with the Northern District of California, when we have a whistleblower, we actually don't disclose the identity of that whistleblower to the criminal authorities. We could encourage that whistleblower to report themselves. But now if we have somebody come in and say, I've been a whistleblower to the criminal authorities as well, it can only make our work easier.
All right, switch topics to cooperation, which we heard about at lunch. Heard about principles and so forth. The SEC hasn't kind of set forth all these principles in writing in any report, I think for maybe 20 years or so. So Kate, I mean, why is it that like DOJ has principles set forth for cooperation and credit and so forth, but the SEC, at least so far, it's kind of a common law way of understanding it? Read these 5 cases, listen to these speeches, and you'll figure it out and trust us. So is that effective in your mind, or what can be done to improve that?
So it sounds like Gerbir is on top of this, and we're going to get his speech published there and a list of all the relevant cases. So you're right. Instead of having this policy out there, we highlight cooperation through our enforcement actions. And I think Gerbir hit the nail on the head there with, nobody really wants to be the subject of a declination. So you are sort of reading into the cases that we have that are out there. But I think that's a pretty broad, vast body of cases. There've been a number filed recently where companies self-reported potential violations or proactively cooperated with the division's investigations or remediated violations or engaged in some combination of those behaviors. And the commission credited that cooperation through reduced penalties or no penalties. So I think you really can look at that body of cases to really find some common themes there.
So, Michele, obviously cooperating, self-reporting, a very difficult step. And we hear about collaborating and we'll go easy on you, confess, tell us all your sins, throw us a few people to go after and so on. Whatever happened to like, hey, you know what, we can beat this thing. And why do we have to tell them? And is it really a good idea to just like, okay, you got us, take us away?
Well, I think that's a great question. And I think the real challenge in this whole cooperation space is, look, the factors that the commission considers, and now we have collaboration added as the fifth. But the first four Gerbert mentioned, like those are the seaboard factors. There's no mystery there. And I think the commission has done a better job in the last year or so of really articulating and identifying the specific remedial steps a company took and specifying what the cooperation has been. So kudos, that's really helpful. But they're not that revealing because they're kind of common sense things based on your understanding of the facts of a given case, what the cooperation or remediation would be. However, I think the real challenge is how do you articulate to a client who maybe is concerned about what is the benefit if we do all this, like what is the actual benefit? And I understand it's always facts and circumstances and you really can't have an apples to apples comparison. But for instance, in some of the 21 F-17 cases, the order talks about remediation, talks about cooperation, that a company like reached out to thousands of former employees to inform them that they have revised their severance agreements and nothing in it precludes you, potential, whistleblower, from coming forward. And they still pay a penalty. So that, I think, is the real challenge, where there isn't, yes, now we've heard Gerbert say multiple times, but again, this has largely been a factor. The most important factor is self-reporting. But there are instances where there's self-reporting and there's no penalty. There's instances where there's self-reporting and there is a penalty. There's instances where there's no self-reporting and there's no penalty. So how do you, maybe there's AI can create like a chart and figure out what is the specific benefit, recognizing it's caveated, facts and circumstances, all of the above, and putting aside the situations where Gerbert alluded to, where perhaps a fraud was so pervasive and it was at the highest levels that the company's going to pay a penalty regardless. But I think what happened over time, and you'll have to humor me for a second, but having been at the SEC for so long, who was there when Harvey Pitt, actually penned the Seaboard report himself. When Seaboard first came out, in the first year or two, there actually were several cases where there were no charges brought at all. There was the one case where it was public. So I take a little issue with what Gerbert said when he was talking about the various instances where there are declinations, including when the staff determines there's no evidence to support a violation. Well, I don't really see that that's crediting cooperation. There was an early determination that the staff looked at something and there's nothing there. So that I think wasn't really addressing when are there the declinations, or when he did say there are reduced charges. And again, you can sometimes divine when you read the order what the charge is, and the summary seems like, oh, maybe this is a more serious fraud, and there was cooperation and remediation and self-reporting, and so it ended up in a reduced charge. But again, it's trying to discern from the tea leaves and extrapolate from that. And then, to your point, trust us, we'll do the right thing if you do the right thing. And I think that's where there's a little bit of a challenge.
Yeah, and it seems a little counterintuitive to, okay, client, here's this thing. Maybe it's a violation, maybe it isn't. I got an idea. Let's just call up Monique right away. So we get credit for being early and say, we're not sure, maybe there's something here, but we'll keep you posted as we try to figure it out. So, I mean, is that, Monique, what you're expecting companies to do?
Realistically, no, that's not what I'm
Good.
expecting companies to do. I think in an ideal world that would happen, but realistically, I think Michelle's just said that's not what her clients are going to do. But I think the DOJ whistleblower policy actually adds a little bit of a spin to, sort of an incentive for reporting earlier.
For individual and for companies to report early, yes.
But that's not something new, right? I think ever since the whistleblower rules became effective in the analysis of whether to self-report or not, a company has to assume in this environment there's a strong likelihood that a whistleblower might come forward. So you have to make the best assessment you can of whether you should get in front of that.
And Jina, in terms of the criminal side, do you see any difference in that kind of credit?
I think that the SEC's whistleblower program has been a game changer, and the idea that there are incentives out there for individuals to come in and tell us about conduct creates a clock. And I think you heard that earlier on one of the panels earlier today, that there is an incentive to move quickly in this space. I think part of our whistleblower pilot is not only kind of based on the success of the SEC's program, but also kind of on antitrust leniency program and amnesty program.
The first in program?
First in.
Right. All right, wanted to switch to...
Can we just talk about one more thing?
Absolutely. Go ahead.
So the other aspect is the encouraging internal self-reporting and giving an opportunity for the company to respond. And so the SEC, if all the criteria are met and there is an enforcement action that results in more than a $5 million penalty, the fact that an individual reported internally first will be viewed favorably for the whistleblower. However, since it's not a requirement, then, I think that creates another challenge where, again, based on my limited experience, where sometimes you get a whistleblower complaint that, really isn't substantiated, to give the company the opportunity to, investigate it and determine if there's something there. I think that's an important, corporate and public policy goal. You want to encourage individuals to come forward and give companies an opportunity to investigate and identify if they have a problem.
All right, wanted to switch topics to off-channel communications, which Kate's going to talk about a little bit. There was a sweep, and is it still an issue, and why, and what's going on in that area?
So, as I think Gerber mentioned when he was talking to Dabney earlier, it definitely is still an issue. We're continuing our efforts to ensure that regulated entities, which include broker-dealers, investment advisors, and credit rating agencies, are complying with their record-keeping requirements. Again, I'm saying what's already been said, but I think it's highly important to our investigations for the reasons that Gerber pointed out, that it helps us move things faster, which can be actually a benefit to the company to have these communications. So, since December of 2021, that sweep has resulted in charges against nearly 60 firms and over $1.7 billion in penalties for failures to maintain and preserve electronic communications. Just last month, we filed the first of these against an unaffiliated standalone IAA in the Senvest matter. And in February, we filed a batch of charges against 16 firms who agreed to pay more than $81 million to settle charges for widespread record-keeping failures. So, yes, I think it is still an issue. And
do you think compliance has improved?
I do. I mean, I completely agree with the statements of other people that this has had, just a huge impact. And, it may not completely solve the problem, but I think certainly the industry is on notice.
Jordan, can you believe that number? $1.7 billion for a record-keeping violation.
Yeah, it doesn't seem a little off, doesn't it? I mean, is that what the off is, an off-channel? No,
I don't think
that's
so.
a lot.
I think that is, there were the Wall Street banks, but I do think
1.7 billion. So it wasn't that much money, is what you're saying.
I would say that maybe the thought was that's what it's going to take.
That's what it's going to take. Yeah, could record-keeping violations lead to any other kinds of charges? Are we seeing that in any other trials in this country? Oh, wait a minute. That's something else entirely. We're going to have a jury verdict in a week or so on that one.
I do have to say, though, that, I think when it comes to personal devices, that is very much where evidence resides for our cases. So, and I think that the initial case that kicked this off, the JP Morgan case, I think there were some facts set forth that, this really came about because they were looking for evidence in an investigation. And
so it's one thing, broker dealer, and But when you're talking about personal devices, I think we on the defense side at least, you're trying to collect documents from, let's say, a director of a public company, just as an example. And that director's on 3 boards and is also an executive at another company and has a laptop and a phone and email accounts all over the place. And it's a daunting task to even get hold of all that and segregate it out. And I don't know, I mean, Monique, does your office appreciate the difficulty of getting hold of that? Or is it's like, no, those people, executives and directors, should have all of their business discussions on one device with one server? Or how do you view that?
I mean, I think in an ideal world, yes, and we do appreciate how daunting it is, but we often see that in an investigation, an individual director is going to have his or her own counsel who can actually be very instrumental and useful in helping to sort through that evidence and figure out what on a personal device might be relevant to an investigation.
Michele, do you counsel clients about how they should keep their executives' documents and their personal, which devices they should use, which services they should use, encryption and all of that?
I mean, when the issue comes up, sometimes in hindsight, yes.
I love counseling in hindsight.
Know,
it's
right?
the best way.
What have you learned from now? But the thing of it is, it's just a challenge for everybody, right? Even you think, okay, well, just eliminate being your own device and just issue a company phone. But even if you issue the company phone, what's going to stop somebody from, just the convenience of texting on their personal phone? So it is a challenge for sure. And the point you raised, Jordan, is a really good one. A lot of board members are on board. They have their own companies or on boards of other companies, and then it becomes a really challenging endeavor and an expensive one and an unpleasant one because nobody wants to turn over their personal devices to anybody.
God forbid a lawyer has to look through it.
Yeah, and we don't want to look.
No, I'm not interested. Really not. Okay, a little detour towards the fascinating subject of subpoena enforcement and one Elon Musk as an example. So I always thought if you issue a subpoena for someone's testimony, they want me in the home office. I guess I got to go to the home office for a day or two for testimony, and that's just the way it is. But it seems like these days, and maybe part of it is remote, maybe I don't have to go fly across the country, and maybe I don't have to do it for 2 days, and maybe I can challenge some of these things. And Monique, I know you've been involved in, I bring up the Elon Musk one just because it's the most known, but what leeway do people have to say, I don't want it to be this many hours, I don't want it to be in person, and I don't want it to be in this location?
Well, I think the order from Judge Corley speaks for itself. I think there's some leeway, but Elon Musk is certainly not the first person that the SEC has ever asked to sit through more than 1 day of testimony. And there's a lot of reasons that were discussed in oral argument in that case about why it may be the best practice, actually, to call somebody in early and then have to call them in again later.
Best practice for you.
Well, actually, I don't necessarily think that's true. I think that when you bring somebody in early, you talk to them, you look through a bunch of documents, and you may realize you don't need anything else from them. I think it can actually set sort of a quicker course for the investigation by talking to someone at the outset rather than waiting until the end. So I don't think that's always true. We don't bring very many subpoena enforcement actions. Fortunately, we don't have to. I think most people work well with us. We actually are accommodating as much as possible. But I do think remote testimony is becoming less and less of an ideal. I mean, we were forced to do it during COVID, but now we have pretty much swung back to in-person testimony, and there are so many reasons to do that. It's really hard. I mean, I don't know how many people have been on a Zoom call or a WebEx that didn't have an issue. I mean, that's number one. You have issues with those. Number two, it's really hard to assess someone's credibility unless you're sitting in a room across from them. And I think we all recognize that. And not only do we want to assess their credibility, but we actually want to give them the opportunity to present their best testimony, best self to us to observe that.
Michele, any luck in getting the SEC to say, well, gee, we don't have to take as many days, or we can do it in a different location, or it can be remote, or is that something you think, forget it, that's not going to work?
No, we've been successful. I mean, I'm still behind the scenes, but my understanding is we've been successful in negotiating.
You've heard,
I've heard, yeah.
You've heard that there is room to.
There is room, yes.
Right. So you don't have to fly someone cross country for 3 hours of testimony.
Right. I mean, we did in one matter, but, like that's the commission, like they can do it, so they did it.
Okay. So I wanted to. We're out of time? Oh, okay. One very quick one, okay? Just because people are in new positions, just tell me one thing you miss from your prior position. And we'll start with Michele. We'll go down here and we'll end with Kate. What do you miss from your prior position?
No, there's a lot of things I miss. I miss like the administrative subpoena power.
Excellent. Monique?
I miss actually having a lot of time to focus on legal work.
Okay. Jina?
I miss 24-hour IT support.
That is definitely worth having. And Kate?
Well, I think like everyone in LA miss having Michele around.
There we go. Oh, all right. That was worth the extra minute, wasn't it? Okay.
Thank you, Jordan. Great job. Thank you to the panel. And Kate, thanks so much for joining us remotely. That worked out great.